All rise. Ladies and gentlemen, the Supreme Court of Alabama, hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court. Please be seated.
Three of our justices will be participating remotely, and they have been emailed the exhibits so that they will be able to follow what will not show up on the screens for them. So, Madam Clerk, will you please call the docket?
In case number SC 2023-0250, Alabama Plating Technology, LLC, v. Georgia Plating Technology, LLC, DVEST, LLC, and Jen Kim. In case number SC 2023-0271, Georgia Plating Technology, LLC, DVEST, LLC, and Jen Kim, v. Alabama Plating Technology, LLC. Arguing for the appellant and cross appellee, the Honorable Ben Coulter. In arguing for the appellees and cross appellants, the Honorable Royal Dumas.
And just a word of explanation before we get started. Each side is allotted 20 minutes. The appellant goes first, and then they're able to close. And so in order to do that, they will not use all of their 20 minutes at the beginning, but reserve some of that for closing. So with that explanation, Mr. Coulter, let's begin.
Mr. Chief Justice, other justices, associate justices, may it please the court. This case is about Georgia Plating Technology and Jen Kim's inattention to and refusal to abide by the asset purchase agreement and the parties' related agreements. These were sophisticated parties, represented by counsel, that negotiated the asset purchase agreement, record site 25 through 61, and promissory note, record site 63 through 68. And what the appellees are essentially asking this court to do is to rewrite the deal after the fact. The primary issue before the court today is whether, in light of the central factual findings of the trial court improperly stopped short of applying those findings to the remaining claims for indemnification that were denied in the trial court's final judgment order. And those crucial findings are, number one, in paragraph number 1, a finding of a merger clause and that there were no bad faith by any parties. Paragraph 5, that the first notice was given and governs indemnification under 11.5 of the asset purchase agreement. Number 6, that notice was given under 11.5 and 11.7. In paragraph 7, in which the court finds that Mr. Kim and GPT, Georgia Plating Technology, failed to respond with any reasonable detail. And last but not least, 8 and 9, which discuss the second notice and the set-off. Today I'd like to do 3 things. Number 1, I'd like to begin with a brief statement of the case. Number 2, I'd like to give you a brief overview of our arguments on the issues of inoperable assets and attorney's fees. And number 3, I'd like to discuss those 2 points, the 2 critical issues, the repair and replacement of inoperable assets, in other words, personal property, the line, the brake plating line, and discuss attorney's fees.
Mr. Coulter, all the justices have read the briefs and the record, so we really don't need the overview. We need to go to the issues that are in contention.
Absolutely, Your Honor. I will do just that. The issues in contention, number 1, are the claim for indemnification of inoperable assets and inoperable assets. Now, there's 2 ways to look at this. Number 1,
but let me stop you there. Before we get to the inoperable assets, is it your position that 11.5C governs the indemnity demands here, as opposed to 11.5B, which is about third-party claims, or 11.6, which I can't figure out what 11.6 is about?
Our position on 11 is that the initial claims for indemnification are uncontested claims, and they're governed by 11.6, and that is the board to the left, which deals with the claims that were made in the August 7, 2019. The indemnification claims that are at issue beyond the uncontested claims in 11.6 are governed, yes, by 11.5C, and also 11.2 itself, which states that the sellers, in this case Georgia Plating Technology and DVEST, Mr. Kim as the equity owner, are responsible for indemnifying in toto for losses that arose prior to the closing, which was April 1st of 2019.
Right. The trial judge says 11.5C governs everything, right?
Yes.
And I understood Mr. Kim to admit in his testimony 11.5C governed everything, right?
Yes.
Are you telling me you disagree with that?
I disagree to the extent that 11.6 does govern the uncontested claims. And I do believe that the court made findings along those noted that as well, which is finding in paragraph 5 and 6 that there was notice given and that there was a failure to respond properly.
Which is 11.5C says that too.
Right.
So why do you have two parts of the contract that both speak about claims and non-responsiveness to the claim?
I think the reason that there is two parts of that is there's two parts of dealing with particular types of claims. One would be claims brought by a third party. In other words, if there was a lawsuit brought against Alabama Plating Technology related to events that had occurred. And the other is things like that are more at issue with this case, which are the issues related to environmental liabilities that were assigned between the parties and the warranties and representations made concerning the ability of the assets, the inoperable assets, to function.
Well, the environmental claims are ones brought by ADEM, right? So you could say they're a third party.
Certainly. Yeah.
But Mr. Kim admitted in his questioning that environmental matters are covered by 11.5C.
Right. And I do think also that it is governed. The claim for indemnification is made under paragraph 11.5. I think there's also relevance particularly in the environmental situation, as to paragraph 2.3, which are retained liabilities. And in particular, as to the environmental claims, I believe that is paragraph 2.3G, in the liabilities concerning inoperable assets being 2.3 and 2.3L, the warranty claim and the unpaid accounts payable 2.3K.
So I stopped you in the inoperable assets. Tell me why the trial judge is wrong in his finding that the inoperable assets are not recoverable.
Okay. Two reasons, Your Honor. Number one, as far as the uncontested claims, in other words, these claims to my left here, which all came in the notice that was given August 7th of 2019, the trial court found, and I think that's one important thing to note about our argument. Our argument is the trial court made the right factual findings, but then made an error as to inoperable assets on applying their interpretation of the contract. As far as these claims, the first $100,000, $105,430, the trial court found that there was a failure by Mr. Kim and GPT to respond in any reasonable detail to that claim. And so those claims then, the original claim for inoperable assets, are uncontested. And they should not have any question about them whatsoever under 11.5C and under 11.6.
But how significantly do you have to contest them? Because it looks like his correspondence contested. It just may not have provided the level of detail to explain specifically why he disagreed. So is it just, can you blanketly say, I disagree, and you're saying that doesn't qualify?
No, Your Honor, it doesn't qualify. The responsibility is to provide a level of reasonable detail. And his position was he sent an email, and the email said, I insist on following the provisions of the contract. I'm going to speak with my lawyer and get back with you in a month or so. That, while it does say I disagree, it's in a sense a way of saying I disagree, it does not meet the requirements whatsoever of saying, I disagree because of this, I disagree because you haven't provided verification of certain payment amounts.
But let me, so Mr. Kim is a layman. Or are you relying on his testimony to interpret what the contract actually says? I mean, is his testimony dispositive? I mean, he can testify what he thought it meant, but is that, do you take that into consideration given that he's a layman and trying to interpret what are fairly significant, indemnification's kind of complicated, and you're putting the burden on him and his testimony to say what he thought it meant or what it said, and is that not misplaced maybe?
Mr. Coulter, your red light is on. Your initial time has expired. You will be allowed to answer this question. And Madam Clerk, will you please add the time for the answer to the question to the other side's time?
I think it is fair to ask Mr. Kim to respond in reasonable detail, given that he was represented by counsel in the transaction, negotiated the terms of that, and also admitted at his trial that not only did he not respond in reasonable detail, he didn't respond in any detail whatsoever, which is page 225 and 227 of the transcript. And in fact, his testimony was that he did not even bother to go through the invoices to determine what would be applicable or inapplicable.
Thank you, Mr. Coulter. Mr. Dumas?
Chief Justice Parker, Associate Justices, may it please the Court. My name is Royal Dumas. I'm proud to be here today on behalf of Georgia Plating Technology, LLC, DVEST, LLC, and Jen Kim. My opening argument answers your questions, Justice Cook. The interplay between this case relates between 11.5b, which is our argument G, and 11.5c, which is their first argument. Distinction is between third-party claims and what the contract calls liability claims. They've argued repeatedly that 11.5c relates to all the claims. There's 3 environmental claims, ADEM to APT to GPT. There is vendor claims to APT to GPT. There's no other way to interpret those in layman's terms than third-party claims. The inoperable assets is a 11.5c issue. If you look at the beginning language of 11.5c, it specifically says, if within 20 days after the receipt of a claim notice or a claim not involving a third-party claim, it specifically accepts third-party claims out from consideration under 11.5c. So then we turn to 11.5b. It reads, if any claim notice identifies a liability claim brought by a third party, that's a third-party claim. So it's a liability claim brought by a third party. 11.5c is a liability claim. So their argument that liability claims have to proceed to a lawsuit to be a third-party claim disregards the actual language of the contract. In fact, liability claim is defined as any claim that such party has that may result in a loss. Loss is defined as losses, damages, liabilities, deficiencies, claims, demands, suits, causes of actions, proceedings, judgments, interest, awards. Cornucopia keeps going on. So the argument that we can use Blacklaw's dictionary in this situation when the term is defined is simply incorrect. All of the third-party claims flow through 11.5b. And this is important because once we're in 11.5b, we're in a different world. There are 2 ways that claims could be handled. The first is that the indemnifying party, GPT, could handle those claims, defend those claims, and there's certain responsibilities they would have to have. They'd have to fully bond, indemnify the indemnified party, but they chose not to do that. The indemnified party defended the claims, APT. And if APT defends the claim, there's a provision. The last sentence says, if the indemnified party assumes the defense of the third-party claim, the indemnified party, APT, will not consent to the entry of any judgment or enter into any compromise or settlement. The uncontroverted testimony at trial was this never occurred. We've briefed it. APT doesn't even pretend to say that they sought the consent of GPT for any of these.
So let me stop you there. So by your definition, at least some of the claims here would be under 11.5C, right?
Yes.
The inoperable assets are under that, right?
Inoperable assets are under the only claim under 11.5C, Your Honor.
Okay. So then we get to the environmental claims, and there are basically two. There's the SID,
Yes, Your Honor.
the storage tank thing. That was actually something that was given to GPT before closing by ADEM, and then GPT came up with a remedy for that before closing, and GPT put that, as I understand it, put that remedy attached to the asset purchase agreement, right?
I think if we look at what was going on, as Mr. Kim's testimony, again, uncontroverted, is in January when it was determined the terms of the deal for $11.06 million, then Mando's representatives through, at that time, an unincorporated agent.
I'm not interested in the negotiation. I'm interested in the SID violation happened while GPT was in charge of the plant.
Yes, Your Honor.
Notice was given by ADEM while GPT was in charge of the plant.
Yes, Your Honor.
The plan to fix the SID violation was done by GPT while GPT was in charge of the plant, right?
Yes, Your Honor.
So there's no real question about that being a third-party claim because it was done. It became a retained liability on behalf of GPT, right?
The consent order was, I disagree, Your Honor, because the consent order was signed after April 1st, after the APA was executed.
The plan was something that was done by GPT and given by GPT's vendor to ADEM as represented that they were the authorized agent for GPT, right?
There was an initial plan created, Your Honor.
Okay, so the second violation, the hazardous waste violation, happened while GPT was in charge of the plant. ADEM came and inspected it while GPT was in charge of the plant, right?
There was inspections. Whether that occurred on the second one, the notice as to the second environmental claim came after April 1st, 2019.
And then ADEM proposed a remedy for that in a consent order, right?
Yes, Your Honor.
That was after APT had taken over the proposed consent order, right?
Yes.
And APT sent that to you as a part of the first claim notice, right?
Yes, they did. And they settled it, I think, a month and a half later.
After you'd had the proposed consent order. And you didn't say anything ever about the proposed consent order, did you?
No, Your Honor, we did not. But I don't think it was the proposed consent order. I think that it was a plan that was in place at that point.
The notice, I've looked at it.
There is a notice.
The notice attached the proposed consent order, right?
Yes.
And no time did GPT object to that.
No, they did
So
not.
the last clause of 11.5B was satisfied because the rest of 11.5B, which you didn't read to us, says unless that consent is unreasonably withheld or untimely. And so you didn't ever object to the consent order that you received.
We did not.
Mr. Dumas, I want to take you a different direction, and this really kind of picks up on the line of questions that were being asked of Mr. Coulter right before he sat down. And I may come back to this, Mr. Coulter, when he's back up. But the question whether APT acted as soon as reasonably practicable, and also the question about whether GPT objected in reasonable detail, is that a question of law, a question of fact, or is it a mixed question?
Your Honor, when you said, did they give notice reasonably and did GPT give reasonable detail? I think the reasonablement of the notice and the delay and the prejudice that resulted, that is a ora tennis as we come here. That is not a question, laws applied to fact, that is de novo. But the reasonable detail is because you have before you the actual email. It's not based on testimony. It's that email applied to whether that provides enough detail. And I can discuss both if you'd like on the inoperable assets. On the inoperable assets, the court ruled specifically that within a week of the APA being signed, APT knew of these inoperable assets. 4 months later, they gave notice. At that point, the assets had either been discarded or destroyed. In a different situation, we'd be talking about spoliation of evidence. That is prejudicial. The trial court specifically noted that we were not able to make a meaningful analysis and get a good faith objection due to the destruction of the evidence in the delay, and it was prejudicial. As a result, we don't waive or consent to the indemnification. Now, Justice Cook, you mentioned 11.6a, and I agree. To get through this indemnification, we need a coal miner's lantern to get there. But if you look at 11.6a, which they put their hat on, they argued, well, it's uncontested. So apparently we just skip over 11.6 and we go to 11.7 for write-off. But that's not what 11.6a. 11.6a, b, and c are resolution of claims. And 11.6a says uncontested. And it says, well, if you don't object, then you've been deemed to have waived your objection except for the limitations in Section 11. And one of those limitations in Section 11 is if APT delayed to give notice and it prejudiced. And that's how the court got to understanding that the inoperable assets were not a viable indemnification claim.
Let me ask you about the inoperable assets. Now, as I understand it from reading the record, before GPT closed, they had a vendor draw up the repair list for those inoperable assets to JP Technologies. Is that not true?
What we've briefed in this is that actually APT did due diligence to determine if there were any inoperable assets, and there were none.
Isn't it true that GPT hired JP Technologies before the closing and had them do an analysis of what needed to be repaired on brake line 2 and sent them a cost estimate that arrived after APT took over?
That is correct.
So GPT was fully aware of the production problems on line 2.
I don't know if they were fully aware. There was some awareness of some issues, Your Honor.
And in the claim notice that APT sent in August, they also sent pictures of those inoperable assets, right?
They did. They also sent a list, which in the initial depositions could not be correlated to any assets purchased. And they also, as we've talked about, there was a claim notice of August 7th, which had the 4 original claims. I think that they're up there as their exhibits, and I think we're looking at $225,000. And then a December 31, where there are further assets included with an increase of, as we see, $360,000.
Yeah, the original estimate, the $105,000, is based upon GPT's estimate, right? GPT's work.
I don't believe that that's true, Your Honor.
GPT's vendor, JP Technologies, gave them the $105,000 estimate, right?
Without getting into the distinctions at that trial, there was the argument that from December on, GPT did not have effective control of the plant.
I understand.
Yes.
All right, so while we're on that thing, so there's a due diligence phase that happens before any closing, whatever, and there's somebody that comes and they basically write a report and says everything's okay. At what point does GPT get to rely on that report that was done before closing? In other words, if there had been a problem with it, I mean, closing has to mean something, correct? I mean, you have a closing and that means that things are closed, things are resolved, or at least the contract is now fully implemented. How are we supposed to judge these kind of two competing interests between a vendor coming and examining line 2 and saying you've got these deficiencies, and an inspector that would be like any inspector when you have an asset sale, inspects the equipment and they say everything's fine? I mean, how does your client then look at both of those and figure out, well, which one is right, that we need to fix it, or somebody that says everything's fine, or is that fine, normal wear and tear accepted, or what exactly does that mean, and how are we supposed to balance those two competing factual issues?
I think we balance those, Your Honor, or you, Honor, or balance those specifically by looking at the language of the agreement. Any asset purchase agreement is going to assign risk to different parties. For instance, we've talked about the environmental issues. While my client vehemently disagreed that he was accepting the risk for those environmental issues after closing, the language in the APA, as the court found, probably rightfully concluded that belonged to GPT. Conversely, the risk on inoperable assets related to APT. And there was a procedure for them to be made whole after the closing, and that's the indemnification process we are here today for. They can go through 11.2, and as soon as practicable, they could give notice, which at some point, that's between April 7th and some date that was, as the trial court said, before August 7th. And in that point, then we could make an analysis, good faith objection if need be. We were not afforded that right. And I think that that's how we balance the risk in this situation, Justice Sellers.
The fact that you're not afforded that right is really the linchpin of this, that if you had an opportunity, you would have inspected and maybe disputed what the total amount was. Is that the...
I want to answer that in two parts. That's absolutely correct. I think it's prejudicial that we did not have that opportunity, and we should have had that opportunity. But I think more holistically, for the other issues that are going on in this case, Mr. Coulter said this today, it's been several times at trial, that this is about a recalcitrant seller who doesn't want to follow the provisions of an agreement. That is wholly untrue. Now, there are times, the response to the claim by Mr. Kim is one of those where when you have an individual who speaks English as a second language, who was represented by counsel, but their counsel doesn't receive the notice, there is correspondence between counsel for APT and an individual represented by counsel, and let's be clear, this issue is a de facto argument, a post hoc argument, because when we come to December 31 with the second claim notice, which is not really discussed in their briefs, they make the same claims with vastly increased damages and a new claim. Within that, they say it is time to negotiate in good faith. And they said that because in September, Mr. Kim went to the CEO of Mando Corp., who's the sole owner of APT, and said, under this contract, we've got to negotiate in good faith. And he says, well, let's wait till we establish the full figures. They send the full figures in December 31. They say we're going to negotiate in good faith. There's an objection to the updated claim on January 17th, and then the procedure stops. They want to stop at 11.5. They don't want to engage in the resolution series found in 11.6b, and for that matter, 11.6a.
So at what point are they allowed just to do the self-help remedy of offset? I mean, at what point in the contract are they just allowed to say, we're just going to offset, we're not going to send you the $400,000? Isn't that essentially what happened? I mean, this good faith bargaining, at some point somebody said, let's cut to the chase, we'll just offset it, and then, we won't have to pay the money.
Well, 11.7 is the right to offset provision. And 11.7 specifically says that you can offset claims that you're entitled to. It's not claims which you believe you're entitled to.
Those would be the uncontested claims, right?
No, Your Honor. I disagree. Because we've now skipped from 11.5 to 11.7, and we forgot 11.6. 11.6a specifically relates to uncontested claims. It says even within an uncontested claim, one, we have the exceptions, which we talked about. Furthermore, it says that in that case, they can go to a court of competent jurisdiction and get an order. They didn't do that. They did do the rule of due. They set off in spring of 2020. At that point, they've increased the figures. For the first time, they make claims for their attorney's fees, which they admit is under 11.2, which, as we've discussed today, then flows down to 11.5c. So they have to give a notice of claim, which they didn't. And they went directly to offset, setting $400,000 off, and then setting portion of the second payment off.
But they gave you the set-off notice, and you didn't respond at all, did you? So the first set-off notice,
there was no
April of 2020, and you didn't respond to the second set-off notice in April of 2021, and then you responded late to the set-off notice in April of 2022, right?
Yes, the response was not needed, any of those. The first response was not needed because there was no entitlement, because they'd objected, one, and to the extent they didn't object, those claims that we've talked about before, third-party claims, which went under 11.5b, and they did not give us proper notice of the consent. So the objection, and again, they're totally skipping over 11.6.
You didn't tell them that. You didn't stop and say, objection, you didn't, this is contested under 11.6B. You should use that procedure. You didn't do that.
In regard to the right of set-off?
Yes.
That did not occur. By the time the 2022 occurred, we were deep in litigation.
So let me ask you about the good faith negotiation, because they did ask that in the December 31 second claim notice. They did ask to go negotiate, and y'all sent a response on January 17th, right?
Yes, Your Honor.
And you didn't offer to go do that negotiation in that response, did you?
There was not an offer in that response, but in the September 4th email from Mr. Kim to Mr. Coulter, and in a discussion the day before with Mr. Kim to the CEO of Mando, he tried to engage in those good faith.
Then they offered that in December, and you never took them up on it.
I think that there were settlement discussions at some point, Your Honor, but I don't know if
There's no evidence
that's not.
you responding to their offer to engage in good faith negotiation.
There is not.
Let me ask you about the the question of 11.5C and that August notice. And so they give you the August notice, and there's really no objection. There's just a response in an email. I've received this. I'm going to get with my lawyers. I disagree with these provisions, and he quotes 2 provisions from the contract. Okay. You could have objected at that point to the timeliness of the notice about the inoperable assets, right? You could have said, you're untimely, we've been prejudiced, stop it. And you didn't do that, right?
There was no objection to untimeliness in that first email.
And then when you responded to the second one in January, virtually the entire response is about how APT has been untimely, right?
Yes.
So do you think that you had an obligation under 11.5C to raise the untimeliness of the inoperable assets notice?
No, Your Honor. In this case, there was, by all accounts, you've read the email. Again, Mr. Kim, as an English as a second language, and I see my
Yeah, and we'll continue like we did with the first counsel up, that you may continue to answer your question, and Madam Clerk, please account for it for the next closing.
Yes, Your Honor. The portion that's at issue is not whether it was written, it's not whether it was in good faith, it's reasonable detail. And reasonable detail, by no accounts, means exhaustive. Reasonable detail doesn't mean it needs to be correct. Reasonable detail just means it needs to place the party on notice. And we're looking at this again as the flow of how this indemnity section works. This is the initial stage where we're at 11.5, whether we're at B or C. After that, then you move to 11.6, which has the good faith negotiations. And at that point, if those fail, if they get a judgment, then they become immediately payable.
Okay. Thank you.
Thank
you, Justice.
Mr. Coulter?
Mr. Chief Justice, Associate Justices, may it please the court. Mr. Kim's testimony at the trial about this very issue, about what he would have done or agreed to indemnify, in response to the question, it was always going to be 0, 0, 0. His answer to that was correct. And that's on record on the transcript, pages 128 and 129. So the question of whether or not he would have ever taken advantage of the opportunity to do certain things, or whether or not there was any prejudice in the length of time, the 4 months, I think is dispositively answered there. He was never going to agree to indemnify. And it's been suggested, and there's been some discussion about the length of time that it took to make the claim for indemnification. I want to address that issue head on and talk about what the evidence really says. And I agree with Justice Mitchell's question about what is the standard of review of these 2 key issues. The first issue being, was there a response in reasonable detail? And second, was there as soon as reasonably practical? As far as the question of reasonable detail, I don't think there's any question that's ore tennis. It relied on the testimony as a combination of oral testimony and the document, which is the email that was discussed. And I think the trial court is entitled to deference on its interpretation of whether or not that response was in reasonable detail. As far as the second question, whether or not it is as soon as reasonably practical, that is a question of interpretation of the contract. And I think there's arguably a distinction between those two, but I think it ultimately doesn't matter, because whether or not it's ori tennis on that issue, or whether or not it is a clear error required to be shown to disagree with the court's interpretation, the trial court's interpretation of contract, you come to the same conclusion. And that's because there has to be some evidence. It doesn't, the trial court is not entitled to just simply go on the arguments of counsel. And I think it's important to look at what the testimony really was. For example, Mr. Dumas said here recently that these parts had been destroyed or discarded or destroyed, and then suggested perhaps there was a spoliation of evidence. I would note there's no cite to the record on that. In fact, that was not the testimony at the trial. In fact, if you look at their brief, they cite 3 places in their brief for their argument for material prejudice. Number 1, they cite testimony on page 95 of the transcript, 95, 5 through 14. That includes 3 questions. And the only question that arguably could deal with the question of whether or not there had been prejudice is, were you given inspection rights? And the answer was no. Were you given inspection rights? There's no testimony, I asked to do an inspection. I couldn't see the pictures, and I asked for better pictures. I asked to have my own team go on there. None of that testimony existed at all. The only quote is a quote, were you given inspection rights? The second record site that they point out in their brief is 96, line 20 through 97:14. And that is questions, those questions do not relate to post-closing events at all. They relate to the handling of the line in 2018, prior to even the sale. And then the third site that they cite is, they say on paragraph, page 91, 21 through 23, they cite that line, and the question there is, did Mr. Park, Mr. S.J. Park, did he tell you there were inoperable assets? Did one person tell Mr. Kim that there were inoperable assets? And his testimony was no. But remember, Mr. Kim's testimony as a whole was, regardless of whether or not somebody had told him or not, it was always going to be 0, 0, 0. That was going to be his response to indemnification. And so I think the argument that they are making that somehow they were prejudiced in those 4 months is not grounded in the evidence. And so as far as the question of whether or not it was done as soon as reasonably practical, frankly, I think it's a fair question about whether or not it was not. You know, it's interesting, even in their reply brief, if you look at their reply brief on page 8 of their reply brief, their position is these claims weren't even ripe. I think that's literally the word they use, ripe. These claims weren't ripe as of August. So for them to then stand up and make the argument that we were prejudiced because we didn't have the opportunity to do some kind of investigation, I think is misguided. Now,
Let me stop you there, and I saw that on their reply brief as well. Had any of the inoperable assets been replaced before your first claim notice?
I believe the answer to that question is yes. It's not clear in the record, and I'll just be candid with you. It is not clearly delineated in the record. There is a clear delineation in the record that certain number of parts, and it includes a certain metering pumps, a pH pump, some gear, it's called a geared motor. It's kind of a rough translation. That those had been identified at that point, that there needed to be replacements, and some of those replacements had not arrived because some of them were purchased from Korea. But as of August of 2019, the parts that had actually been paid for included were this $105,430, I believe.
Was my question to Mr. Dumas correct when I said the $105,000 comes from the JP Technologies estimate that was requested by them?
Yes, and I believe that is accurate, Your Honor. That that original number comes from an estimate, and the information we had at the time. And if you look, in fact, at the trial testimony that deals with specifically what costs were incurred over time, you'll see a lot of those invoices and payment records come from after August of 2019. And the reason for that is because they were in the process of replacing things. It took a while to get the lines.
Well, Mr. Calder, I want to kind of ask you the same thing that, you're before closing. You've got a vendor that says these things need to get fixed.
Yeah.
You've got a third party that inspects presumably personal property, assets, equipment, all that kind of stuff, and they give a report that says everything's fine. And like I said, I assume that's normal wear and tear accepted. And then when you look in the court's order, the court seems to indicate that, hey, if you knew there was a problem of this magnitude, and again, it's an $11 million deal, so in the grand scheme of things, this isn't the most significant percentage-wise. But is the court right in their order that, well, you could have stopped the closing, you could have adjusted the purchase price if you knew at that point you were going to have to pay these, versus we've got a third party that says everything's okay? How do you balance those out? And then when you put those things together and we have a court's order finding that you're not going to be able to get compensated for the inoperable assets because of these different things, how are we supposed to, what kind of deference are we supposed to give to the court's order with these different claims that seem to be, contradictory?
I'd say two things to that, Your Honor. Number one, as far as the deference to the court's order, I think the court specifically finds that there is prejudice, and the reason that is important is you are only limited under the terms of the contract to the extent that there is a material prejudice or inability to respond to that claim. In other words, if I knew and I delayed and I waited for a couple of years and made it so it was impossible for you to investigate that is the limitation. And that's why it's so important that we look at what the evidence actually is of material prejudice. So I don't think we owe the trial court deference on that issue, because while it is certainly the argument of counsel that there was material prejudice, it is unsupported by the evidence. As far as the question of how do you balance the issues, what one side knows and what the other side knows.
But it's really both. I mean, it's really APTs, because they've got a vendor that's come in and said it's going to take this much to get line 2 back up to speed so that, it's less than 2%, deficiencies, versus a third party that goes in that apparently does these and says everything's okay. So your client knows all that before closing, and they decide to close anyway.
Right, and I think that's the reason why we started with and want to end, we'll be talking about the entire time, the contract. Is the reason for that is the parties knew there were issues that weren't going to be resolved before closing. Everybody wanted to close on April 1st. And we knew there were issues. We knew there were environmental issues. We knew there were issues with the assets. And we negotiated a contract that retained those liabilities one to the other. So, for example, as I mentioned before, as far as environmental liabilities, 2.3G, we know there are environmental issues. Both sides know there are environmental issues, and we assign that risk to the sellers. And the same thing is true as of to the repair and replacement of assets. I mean,
Mr. Coulter, I want to ask you a question before you sit down. You only got like a minute left. Real quick. So we've got a mixed bag below, which is why we have an appeal and a cross appeal. Right. You're making a claim for attorney's fees. How do you ask us to reconcile, harmonize the provisions in the APA that speak to recovery of attorney's fees?
The number one way that I ask you to do that is by looking at where at 1.1, definition of losses for which we are entitled to seek indemnification includes reasonable attorney's fees and the cost of enforcing any right to indemnification hereunder. And if you ask yourself this question, absent the set-off and absent the ensuing litigation, would Mr. Kim have ever agreed, a GPT ever agreed to indemnify Alabama Plating Technology? And the answer is no. It's very clear. He answered that question. And so losses, one of the things that we are entitled to be indemnified for are losses under paragraph 1.1.
The specifics govern over the general, though, right? I mean, you have a specific provision in the contract dealing with attorney's fees in litigation. That should govern over the general provision. That's the way we interpret contracts and the law generally. So why are you the prevailing party if you lost, if you're not getting any money?
Well, that's a good question. We are getting money. Number one, they would have never agreed to indemnification. Number two, I would point out that the non-prevailing party in this case is Georgia Plating Technology. If you look at the claims, and those are the 6 claims for indemnification at the end, we have the 2 environmental issues, the SID permit notice and the NOV, hazardous waste NOV. That was granted, so we're the prevailing party there. We have inoperable assets, not granted. We have unpaid accounts payable, granted. We're the prevailing party there. MPDES permit, granted. And then legal fees are really a function of
Are we supposed to count the number of issues? Are we supposed to count the counts? Are we supposed to say it was $600,000, 592, and you got 300 some of it? How are we supposed to decide who's the prevailing party here if we're not going to just say who got paid money?
I think that's a very fair question, but the law that we cite, number one, just a simple explanation of who's prevailing party is that a prevailing party is a party in whose favor a judgment is rendered. That's just Black's law. But if you look at the cases as well, prevailing party is one that we cite the Buchanan Board and Care Home, party who's been awarded some relief. And look, here's the critical issue. The court found that we were entitled to indemnification, something that was denied the entire time. If you use a slightly different analogy, basically the same thing. If we filed a breach of contract action, we said, you owe us $100,000 for 5 different things, and the court came back and said, you're entitled to $400,000 of that $500,000, I would still count that as a win. We won our breach of contract action because they were denying the whole thing.
If we gave you everything you want, and I'm not promising that, but let me tell you, I'm not. If we did that, you got a footnote there.
Yes.
What were you asking us to send it back to the trial court to have them award some more fees, or what are you saying here?
Yes, I think what I think should happen is the court should be overturned on inoperable assets and legal fees, and we should be remanded and given leave to prove up our fees since the date that was submitted. And because
put that anywhere other than just telling us that? Is that in a pleading someplace, or is that an ancillary matter and the court gets to keep jurisdiction? I'm trying to understand how you get to do that.
Under paragraph 14.8 of the contract, the prevailing party is entitled to its legal fees both in the litigation and on appeal. And I believe the trial court, the parties agreed prior to the trial that we would reserve any fees after this for a further determination after the court had ruled.
Is that in the record someplace?
It is.
Can you?
It's at the very end of the trial.
Very end of the trial.
Yes, Your Honor.
Mr. Coulter, thank you.
Thank you.
And our thanks to counsel for both sides. We will take this matter under consideration. And with that, we stand adjourned.
All right. The court is adjourned.